appeal in the matter of National Iranian Oil Company and Crescent Petroleum Company and another. Partner.
Yes, Mr. Durrell. Thank you, my lord. I will be short as promised. So I want to address the final strand of my points, which is about Iranian law, and then give a very brief wrap-up, if I may. Now, in my submission, which I set out at the beginning of my submission, Iranian law was not properly, in this case, to be characterized as pure argument in support of a ground for objection, but intrinsic in my submission to fairly advancing the ground for objection, and in order to enable it to be addressed by Crescent and determined by the tribunal. I therefore do take issue with paragraph 38.5 of the judgment, where it was treated as pure argument and therefore not necessary. Now, the reason why I say that are for the following reasons. On Neok's case, emphasized during the course of this appeal, Iranian law is alleged to be idiosyncratic and far removed from principles of construction under English law and international arbitration principles, if I may put it that way. So that begs the question, in my respectful submission, as to how the tribunal or Crescent were meant to appreciate that a point of construction was being advanced upon wording that otherwise was incapable of actually raising a point of construction without the Iranian law restrictive interpretation being mentioned. It is, with respect, difficult to understand why Neok did not advance the core point that was needed to advance the construction point when it was saying, and this is the passage that my ladyship drew my attention to yesterday, when they were saying that Crescent's reference to English law authority was bizarre. And this is all despite the fact, of course, that multiple Iranian law expert reports were adduced on many other issues of Iranian law. I therefore do say that the situation is vastly different to the case law examples, which I haven't taken you to, and I'll just give you the references: Arsenovia, Volume 1, Tab 4, and Habas, Volume 2, Tab 20, relied upon by the court in support of the proposition that invocation of foreign law legal principles in this case was simply argument to support a construction contention in circumstances where I submit the construction contention was incapable of properly being advanced for determination independently of the principles. Putting the point, if I may, in two further ways, in the absence of the principles of Iranian law, what exactly was being put to the tribunal for determination so far as construction is concerned? That's the way I would put it. Or to put it another way, had Neok advanced the construction contention before the tribunal without Iranian law, in my submission, the tribunal would inevitably have had to ask the question, how can this possibly work? What is the basis for this? To wrap up, if I may, objectively speaking, we submit that the construction contention as to the narrow scope of the arbitration agreement, as now articulated by Neok and Dr. Mokarami, was never fairly or adequately put for determination by the tribunal, and therefore should be precluded under Section 73. We place considerable emphasis in this context on the following features. First, we submit a fair reading of Neok's pleading is that it was advancing a different point concerning trespass to privity, and I've had that debate with the court. Second, Crescent did not understand the construction point was being raised as opposed to a trespass to privity point. Third, the tribunal, which was, after all, highly experienced, never understood it to be the case that a construction point was being put for determination, and therefore did not address it. Just pausing there, I'm not aware of any Section 73 case where the point, the jurisdictional point, has actually not been addressed by the tribunal, albeit they're not the final arbiter of the jurisdiction point and goes by way of complete rehearing. I'm not aware of any situation in which the point is not first addressed in the context of a Section 67 challenge, where it's not first addressed by the tribunal. Fourth, obviously, the point I've just been making, no Iranian law evidence led, nor even a mention of restrictive interpretation under Iranian law, despite the volume of Iranian law evidence that was advanced. And fifth, as late as 2019, as I took the court to yesterday, NEOC was taking the position the London Tribunal should assume jurisdiction over matters before the Geneva Tribunal on the basis of Fiona trust principles. And therefore, ultimately, in my respectful submission, the court, I would invite the court to give consideration to what exactly does NEOC say was the point of construction that was being put to the tribunal for determination, and what is the explanation for the tribunal having completely missed the point. We know today how NEOC puts its case, yet not anything remotely analogous to that was put to the tribunal so it could engage with and determine the point. For all these reasons, we submit that this is a case falling within Section 73 because the construction point could and should have been raised before the tribunal for determination, but was not. Those are my submissions. I hope I kept to time.
Thank you very much. Thank you very much. Yes, Mr. Bailey.
May it please the court. In our respectful submission, Crescent's application for permission to appeal should be dismissed for three reasons. The first of those, and perhaps the most important, is because this court has no jurisdiction to grant it. And secondly, this is a point that goes to discretion, but Crescent could and should have sought permission from the learned judge, but deliberately chose not to do so. And thirdly, and in any event, in our submission, the proposed appeal has no realistic prospect of success. I have one alternative submission, which is this, that if you were to conclude that you do have jurisdiction and that permission should be given, then for reasons I'll seek to explain, in our submission the appeal should be dismissed on its merits. Now what I propose to do in the time available is to develop each of those three submissions in turn, beginning, if I may, with the question of jurisdiction.
Yes.
So far as jurisdiction is concerned, it's common ground that Crescent needs permission to appeal. And the reason for that is because that's the effect of Practice Direction 52C, paras 8.1 and 8.2, because Crescent is asking this court to vary the orders that were made by Mr. Justice Butcher. Why that's relevant is because a query was raised by my Lord Justice Males yesterday as to what would be the position if the Section 67 claim had gone to a full unitary hearing, and the judge had decided that the Section 73 point fails, but the claim is to be dismissed in any event. Could it be said in those circumstances that Crescent may not need permission to appeal because it was simply seeking to uphold the judge's order on other grounds? And that was the point, my Lord.
Yes.
Now, can I make 2 points on that? First is this, that my learned friend very fairly did not suggest that the answer to that question was yes. And the reason he didn't is because, as he fairly explained, it would depend upon the terms of the order, and we agree with that. And the second point, my Lord, is this, that the scenario that my Lord postulated is not this case. And what we would respectfully submit is that it may give rise to issues beyond those with which we're concerned, and in my submission it's best left to be decided if it arises at all in another case. So that's what we say about that. The question that does arise in this case and does need to be decided is whether or not the judge's order on the preliminary issue was a decision under Section 67 of the Act. And as the court appreciates, my case is that the answer to that question is yes, and that is so whichever way the preliminary issue was or could have been decided. Now, by contrast, my learned friend's case, the answer depends upon the outcome of the preliminary issue. If the preliminary issue is answered yes, then my learned friend accepts it's a decision under section 67. But if the preliminary issue is answered no, as happened here, and as my learned friend said explicitly in answer to a question of my Lord Justice Nugee, he then says it's a decision under section 73. Now, our response to that is essentially twofold. As a matter of first impression, Crescent's argument is, we would respectfully submit, patently absurd. And secondly, as a matter of analysis, it's wrong. Now, I want to focus, of course, on the question of analysis. And in that context, the decision of this court in the Manchester City case is helpful. And like my learned friend did yesterday, I should like to express my gratitude to the court for bringing it to our attention. And the reason I say it's helpful is because while I accept that the statements were obiter in that case, there are two separate statements recorded in paragraph 39 of the judgment, one by the Chancellor and one by the Master of the Rolls, which in our respectful submission are plainly right and reveal the fallacy that lies at the heart of my learned friend's case. Now, I'm sure you've looked at this before, but can I just remind you what I'm referring to? If you have the Manchester City case to hand, it's paragraph 39. And it's between G and H of the report, where it's said by the Chancellor, Lord Justice Males posited the example of a case management decision about how a Section 68 application should be dealt with. And this is the first statement on which we rely, and this is the statement by the Chancellor himself. As I said at the time, that would seem to be an example of something which is part of the process of reaching a decision under Section 68, so would be caught by the limitation on the right of appeal. And then the second statement, which is attributed to the Master of the Rolls, is in the next sentence. The Master of the Rolls suggested to Lord Panic that a consequential decision on a Section 68 application, for example as to costs, would also be caught by the limitation. Now, as I say, of course I appreciate that both of those statements were obiter, but we do submit that they are plainly right. And the consequence of that in our respectful submission is as follows. Firstly, an order which is made by the court as part of the process of reaching a decision under Section 67 is itself a decision under Section 67 and would be caught by the limitation on the right of appeal. And secondly, a consequential cost order on a Section 67 application or claim is itself a decision under Section 67 and therefore will be caught by the limitation on the right of appeal. Now, if those submissions are right, which in our respectful submission they are, we say that it's clear that this court has no jurisdiction to grant Crescent permission in respect to the two orders which it seeks to challenge. Now, to make that point good, my lord, just to take it a little bit further, can I take you to Crescent's actual application which they're making? And it's to be found in the core bundle 1, at tab 3. I don't think we've necessarily looked at this before, but it is quite instructive. So core bundle 1, tab 3. And it begins at page 46, and it's the respondent's notice served by Crescent. And the relevant part of this document is section 4, which, as I'm sure you'll all be very familiar with, is a section which contains details of the orders you want to appeal. And the name of the judge is mentioned, then the date of the two orders. And the two orders that are sought to be appealed are then identified in the relevant languages set out in the box. So the parts of the order of the 21st of October, in respect of which permission to appeal is sought, is paragraph 1, which provides, quote, the answer to the preliminary issue is no. And then the parts of the 17th of November order, in respect to which permission is sought, are also set out, and namely that the claimant shall pay 40% of the respondent's costs of an occasion by the applications and the claimant's Section 67 claim. So those are the two orders. And what I want to do first, if I may, is deal with the costs order of the 17th of November. Now, luckily that's in the same bundle, so it's tab 8 of the same bundle we're looking at page 99. Now, the important point about this order, and it's clear from the recitals and its expressed terms, is that it dealt with the combined costs of the applications and the Section 67 claim itself. And the recitals I'd asked you to note on page 99, the first recital is it is made upon the claimant's arbitration claim form under Section 67. Secondly, it's also made upon the respondent's application for a preliminary issue as to whether the claimant's 67 claim is precluded. And secondly, on the summary judgment application dismissing the Section 67 claim. And then over the page, two further recitals are relevant. The first is the penultimate one, the one halfway down the page, upon the judgment, which is the main judgment of October 22. And then, secondly, upon the order of Mr. Justice Butcher answering the preliminary issue no. That's also recited. And then significantly, paragraph 1, which is the paragraph my learned friends seek permission to appeal against. The claimant shall pay 40%, so my client should pay 40% of Crescent's costs of and occasioned by the applications and the claimant's Section 67 claim. Now, what we submit is that this order is a final determination of the costs of the Section 67 arbitration claim, as well as the costs of Crescent's two applications. And it is, as the Master Rolls suggested, and we submit correctly, clearly a decision under Section 67 of the Act. Now, if that's right, what is the significance of that? And in our submission, the significance is threefold. The first point is this, that this is clearly a final determination of the costs of the whole action. And importantly, the 60% deduction in Crescent's recoverable costs is a direct result of the fact that Crescent lost the preliminary issue application under Section 73. Now that is clear, we would submit, when we look at the judgment of the learned judge on costs, which again we have in the bundle, tab 12. And if I'd ask very kindly to turn it up at page 137, and if you could be good enough to look at paragraph 3, the learned judge says this: in my judgment, this case is one where it is appropriate for there to be a proportionate order in favour of Crescent on its costs. It seems to me that Mr. Dewan is right to say that it is overall the successful party, and that it is artificial in many ways to treat these as being two separate applications. And Lord, the next sentence is key. They were both directed at defeating the Section 67 challenge to the award. So that's the first significant point. The second one, what is this? That the decision on the preliminary issue, as the order and the reasons make clear, did lead to a final determination in relation to the Section 67 claim, at least in relation to costs. And that is why, what is one of the reasons why my learned friend is wrong to say that the dismissal of the preliminary issue, or rather the answer that the learned judge gave to the preliminary issue, did not result in a final decision either way under Section 67. It plainly did directly result in a decision on costs. And the third point, and this is obvious, is that if Crescent wished to appeal, as they seek to do so, against the cost order on the grounds that the judge had been wrong about the preliminary issue, then it was incumbent, in our respectful submission, upon Crescent to seek and to obtain permission to appeal from the judge pursuant to Section 67(4) of the Arbitration Act. Now the key point, standing back for a moment and pulling all the threads together, is this. Namely that the preliminary issue on Section 73, whichever way it was decided, was always going to be a stepping stone on the way to the final decision under Section 67. So those are my submissions on the first order that my learned friends seek to appeal. Can we then look at the second order, which is to be found in paragraph 1 of the 21st of October order, which also is in the same core bundle 1 at tab 7 at pages 97 to 98. And again, if I could kindly ask you, I'm not going to read them aloud, if you'd be good enough to look at the recitals on page 97, the three there, first being that it's made upon the arbitration claim form under section 67. Secondly, it's made upon the two applications. And thirdly, it's made upon the order of Mr. Justice Foxton, which identifies what the preliminary issue is. And we'll come back to that. And then, when one goes across the page to paragraph 98, the relevant order is that the answer to the preliminary issue is no. Now, I have three preliminary points, if I may, on this order. The first of those preliminary points is this, that it's common ground between the parties, my own friend and I, that this court has no jurisdiction to grant permission to appeal against paragraph 2. My own friends accept that my clients could not say, for example, that paragraph 2 was in fact a decision made under CPR Part 24 rather than under Section 67 of the Act. And
I think he accepted that, given that the Section 24, the Part 24 application succeeded. But I think he said that if the Part 24 application had failed, that would not be a decision under Section 67.
Well, my lord, I'm talking about the terms of the order.
Yes.
Quite accept the procedural mechanism. The point I'm making is the reason one couldn't characterise paragraph 2 as being anything other than an order made or decision made under Section 67 is because such an argument would be hopeless and inconsistent with the decisions of this court in both ASM shipping and also Itochu, which we saw yesterday. That's my submission. Secondly, my lords and my lady, it's also common ground that this court would not have jurisdiction to grant permission to appeal in relation to paragraph 1 of the order if the last word in quotation marks was replaced with the word yes. So, if Crescent's case is correct on jurisdiction, it would lead to this surprising, we would, with respect, say absurd, consequence that this court has no jurisdiction if the preliminary issue was answered yes, but it does have jurisdiction if, as what in fact happened, the preliminary issue was answered no.
Why is that absurd?
Because the court is involved in making exactly the same, the court is involved in making exactly the same inquiry, simply reaching a conclusion. And the nature of the inquiry and the conclusion it reaches, in my respectful submission, must be in relation to the same legal conceptual context. And that is, we would submit to Section 67. I'll come back to this if I may, because I've got other submissions to develop on this very point. But what we say in any event is to seek to distinguish, for the purpose of permission to appeal, whether the court has jurisdiction depending upon the outcome is at least surprising. I submit it's absurd, but it's at least surprising.
I'm not sure I do find it that surprising. I'm thinking back to, under the RSC, you didn't need permission to appeal final orders, but you did need permission to appeal interlocutory orders. If you brought an application under Order 14 and it failed, that was an interlocutory order. Leave to defend is granted. That's clearly not a final decision. But if you brought an application under Order 14 and it succeeded, judgment would be entered, and that would be a final decision. So I don't find it surprising that the question of permission to appeal might turn on whether your application is successful or not.
Well, Lord, I hear what you say, and perhaps I can reflect upon that. As I said, I've got one or two more submissions to make. But at least our submission is perhaps I can put it this way, at this point, and I'll come back to it, is that confronted with a similar possible dilemma in a different case, I think Lord Justice Longmore describes something not totally dissimilar to that, which I've just identified as being paradoxical.
Paradoxical, yes. I think that's a better word than absurd.
Perhaps, if I may, on reflection, respectfully agree and suggest perhaps paradoxical is a more appropriate adjective. But paradoxical or otherwise, looking at this order as a whole, just looking at paragraph 1, 2, 3 and 4 on page 98, Crescent's case that Parliament intended that the only paragraph within that order to which the limitation on the right to appeal applies is paragraph 2, is not only paradoxical, but in our respectful submission gives rise to very surprising consequential results, which I will come on to explain.
Mr. Bailey, just on, it may not make a difference, but if the answer to the preliminary issue had been yes, would the natural drafting of the order be to combine paragraphs 1 and 2 to the effect of, and accordingly, the Section 67 claim is dismissed?
Well, my lady, we would suggest not, and this is perhaps going back to the point that my own friend debated very briefly with my Lord Justice Mayles yesterday about the nature of the order and the fact there are two distinct steps and they ought to be properly reflected in two separate paragraphs or two separate orders. I do, of course, accept that they're consequential, and that's that's one of the points I make about being a stepping stone.
Well,
not on this order, but it
not
would be
on this order, but
no.
in my hypothesis.
Quite, it would be consequential.
Yeah.
Just in the same way as we looked at the cost order, that we say that the fact that the answer given was no was consequential on that was the 60% reduction in my own friend's recoverable costs.
But that costs order, I mean, there may be many cases where a judge will combine success and failure on quite separate issues into a combined cost order.
Quite. Now, it wasn't the form of the order, my lady. The point I was making at that stage of my argument was the fact that the answer to the preliminary issue fed directly into the consequential cost order that the learned judge made, because it resulted in the 60% deduction in the recoverable costs my own friend was able to obtain.
I mean, it's a bit difficult, isn't it, to place too much weight on questions about how orders might have been drafted if things had turned out differently. For example, if the judge had answered the preliminary issue yes, he might not have needed to go on to even think about the merits of the Section 67 application, because that's the whole point of Section 73. And it would have been a matter for him, having heard argument, whether to deal with it in his judgment or not.
Quite.
It's
There may not have been a
difficult to know what he
consequential
would
application
have done.
dismissal. Quite. I agree. It's probably not profitable too much to speculate all the other possibilities that might arise. We are trying to focus on this particular order, and perhaps what I can try and do is help in this way. Because what I'd like to do, if I may, is try and articulate exactly what it is that paragraph 2 means. And what I would suggest that the appropriate way to work that out is to read together the recital at the bottom of page 97, beginning 98, which sets out the question the preliminary issue is answering. And the question the preliminary issue is addressed to is the claimant precluded from advancing the jurisdictional objection in the Section 67 claim by Section 673(1) of the Arbitration Act? And the answer to that is given as being no. So reading the recital and paragraph 1 of the order together, what the order constitutes is a decision that NEOC, my clients, are not precluded from advancing its jurisdictional objection in the Section 67 claim by Section 73 of the Arbitration Act. And once you articulate the order or conceive of the order in that manner, in our submission that helps make it clear why it's just as much a decision under Section 67 as a decision would be that NEOC is precluded from advancing its jurisdictional objection in the Section 67 claim by Section 73. But the key point, my lord, my lady, is that we submit that whichever way the preliminary issue is decided, it forms part of the process of reaching a final decision under Section 67. And that, now submission chimes back with what the Chancellor said in Manchester City. Now, while we have the order open, can we very briefly look at ASM shipping? There's one particular paragraph I don't think my own friend showed your lordships yesterday. It's in bundle 1 of the authorities bundle at tab 5. And the relevant paragraph I had in mind, my lord, is paragraph 18 of the judgment of Lord Justice Longmore on page 70. Where Lord Justice Longmore says this: we add that although there was some argument before us on the question whether the judge's decision was based on Section 73 of the 1996 Act or on waiver at common law, we consider that nothing can turn on that distinction. Permission to appeal without the judge's leave is prohibited in either case. Now, the second point that follows from that, in our respectful submission, is this: that Section 73 is inextricably linked to Section 67. And that's why, or rather that's the rationale for what Lord Justice Longmore, we would submit, said in paragraph 18. Now, you've looked at Section 67. I don't think we need to take it up again, but the point has been clearly made that there is an express reference to Section 73 within the whole body of the text of Section 67 itself. It expressly says the party may lose the right to object, see Section 73. And what we would submit is that, perhaps not conclusively, but the explicit reference to Section 73 within the body of Section 67 is a further indication, a further pointer, that a decision based on Section 73 about the right to object under Section 67 is still a decision under Section 67. To put that point slightly differently, what we submit is that paragraph 1 of the order, which we were looking at page 98 of Core Bundle 1, is a decision on a question which is expressly identified within the express language of Section 67 itself. Now, my lord, can I move to one further aspect of this part of the argument, which is this, namely that when construing Section 67(4) of the 1996 Act, we would submit that you're entitled to have regard to the consequences of the rival interpretations. If authority were needed for that proposition, we have Benyon in the bundles. I'm not going to take it to you, but it's a section, the relevant section is 11.6 in Authorities Bundle 5, tab 55. We can look at it, my lord, if you... It's Authorities Bundle 5 at tab 55. And the relevant passage I have in mind, paragraph 11.6 at page 1383. And if you lordships have the section that begins on that page, section 11.6, regard to be had to consequences, when considering in relation to the facts of the instant case which of the opposing constructions of the enactment corresponds to its legal meaning, the court should assess the likely consequences of adopting each construction, both to the parties in the case and where similar facts arise in the future, for the law generally. If, on balance, the consequences of a particular construction are more likely to be adverse than beneficent, this is a factor telling against that construction.
It's not a very surprising proposition.
No, that's why I wasn't going to take much time over it, but I didn't want to, I know when we were reaching for it, I thought I would take it too. So I didn't think it really controversial.
So I wasn't reaching for
Oh, I'm so sorry, Model. Perhaps I'm sorry.
it. No.
Sorry.
But anyway, we've seen it now.
Yeah, I'm sorry if I
That's
wasted
all right.
time. I apologise.
Don't worry.
But anyway, that's the proposition of law. The question is, what are the relevant consequences here that are relevant to the decision your lordships have to make? Now, the way we put it, perhaps I hope I haven't put it too high, but we've suggested that if my own friend's case were right, and the Court of Appeal were to have jurisdiction to grant permission to appeal in this case, then the precedent that would set we would respectfully submit, lead to at least a degree of procedural incoherence. And the reason I say that is for three reasons. Firstly, it would mean that the limitation on the right to appeal would not apply to case management decisions or orders made on preliminary issues, even though they were part of the process leading up to the reaching of a final decision, to which the limitation undoubtedly does apply. Secondly, that would defeat the policy behind Section 67(4), because not only would it increase the costs, but applications to this court for permission to appeal in relation to interlocutory and case management decisions could well disrupt and delay the final determination of the Section 67 claim by the High Court. I mean, one obvious example is decisions made shortly before a hearing of a procedural, possibly even substantive nature. Permission is then sought to appeal to the Court of Appeal, and it happens that the hearing date for the Section 67 claim could be lost, while applications for permission to appeal remain pending in this court. I mean, that's obviously one would hope that would not happen, but it's certainly a possibility. My own friend's analysis of the scope of this court's jurisdiction is correct. So we submit it would be inconsistent with the policy of the statute for the distinction my own friend seeks to advance to be correct. Secondly, my lord, it would also, we would respectfully submit, defeat the purpose, not just the policy of Section 67(4), but the purpose of Section 67(4), which is to make the judge at first instance the gatekeeper to permission to appeal, and its procedural consequences can then be dealt with promptly and at once, and for all, by the judge that has made the relevant decision. So those are the consequences we would ask you to bear in mind when considering the rival interpretations of Section 67(4) the parties have put forward.
Do you get any assistance from Section 1 of the Act?
Well, yes, I think I do. My lord, I think I do, but can I just turn it up to check my recollection of it is right? Yes. Well, my lord, the sum, I can't take it too far, but certainly delay and expense are two criteria that are relevant, and as I've sought to submit in the context of the point about policy, is that for my own friend's submission to be right, it could well lead to further delay and expense.
I mean, 1A seems primarily directed at getting to the award by the tribunal without unnecessary delay or expense.
My lord, that's right.
Whereas Section 67 applications are necessarily after the award. But does 1A also mean once you've got an award, it should be capable of being relied upon as a final resolution without further delay or expense thereafter?
My lord, I think I don't want to take this too far, but I think there is a general presumption in the context of arbitration, both in the context of the reference itself, but also in the context of post-award supervisory jurisdiction applications, that they should be done expeditiously. I mean, we saw that in Enca. The court in this country moved from December to April to June, 3 levels to decide a point, for the very reason that the nature of arbitration meant that those kind of points which could delay enforcement should be dealt with very quickly. Likewise, this case has been listed. I think the learned judge, in fact, said when permission to appeal was granted that although he wouldn't mandate expedition, it should be dealt with as quickly as possible.
There's a certain irony in this particular case in saying that the object of arbitration is to avoid unnecessary delay and expense. We're, what is it, 14 years in and still going strong?
My lord, that's right. That's right. There is, and I hope I'm not going to open this up, but there's all I would say, there are points to be made on both sides, and I'm not going to start blaming one party or the other.
Yeah, right, I wasn't inviting you to.
But of course your lordship's right about that. But whatever may have happened there, that doesn't mean we should soft pedal.
And I suppose part of the point of Section 67 is to tell you authoritatively whether you have got an award which represents the fair resolution of disputes by an impartial tribunal.
Well, my lord, that is certainly true, but there is another point perhaps I should have made in answer to my Lord Justice Nugee's point, which is that a Section 67 issue may not necessarily always arise at the very end of the reference. It may well be a point that a tribunal would want to decide by way of a partial, of what used to be called an interim award, now be called a partial award under Section 47. So it may well be that it's a decision on the way by the tribunal itself, and the 28 days for challenging would kick in from the date the award is published. So there's
Well, exactly, that did happen in this case. I mean, they thought they'd issued an
Well,
award on jurisdiction.
quite was going back apparently in October to argue for more points.
No, but I mean, the first award on liability was also an award on jurisdiction, wasn't it? And
Indeed, it was, and there was a, as your lordships know, my learned friend, my clients made an application to challenge the jurisdiction under Section 67. It was dismissed by Mr. Justice Burton, as he then was, on the basis that the relevant issue, separability, was to be determined by reference to English law, being the law of the seat. And sadly, for my clients, it was only when the Supreme Court in Enca looked at that case and said it was wrong that the injustice that occurred became manifest. But anyway, that's history. History. But anyway, my lords, I have one final submission on jurisdiction, which is this, and it really pulls together all the points I've been trying or struggling to make. And it's this, that standing back from the detail, the simple answer to my learned friend's application is that the decision on the preliminary issue, either way, on whether or not a party had waived its right to object to the substantive jurisdiction of the tribunal under Section 67, is part of the process, the way the Chancellor put it in Manchester City, part of the process of reaching a decision under Section 67. And for that very reason, it necessarily follows that it's caught by the limitation on the right to appeal. And basically, as Lord Justice Longmore explained in the ASM shipping case at paragraph 18, the fact that it was based on Section 73 is neither here nor there. So for all those reasons, my lords and my lady, we would respectfully submit that together with the points we've made in writing, that Crescent's application for permission to appeal must be dismissed for want of jurisdiction. Now, I'll take my next 2 points slightly more quickly, if I may, then I want to turn to the substance of the appeal itself, if I'm wrong about that. Yep. But the second of my 2 submissions on permission is that we would submit that it should be refused as a matter of discretion. And the reasons for that are as follows, and I've got 5 points to make, very brief points. The first is this, that Crescent could have applied for permission to appeal on a contingent basis at the hearing of my client's application for permission to appeal on the 9th of November. And Crescent had further opportunities at various times to apply for permission to appeal up to and including the hearing that took place on the 20th of December. And that took place after the judge had already delivered his ruling granting my client's permission to appeal, albeit it hadn't been sealed. So there was plenty of opportunity for them to apply to the learned judge. Second point is this, that instead of applying, and my own friends and those behind him are as sophisticated litigators as one can imagine. Instead of applying for permission to appeal from the judge, the strategy that Crescent adopted consisted of an attempt to shut down my client's appeal, first by resisting the application for permission to appeal itself and not positing its own contingent application if permission was appropriate, and thereafter by applying for a draconian condition that my clients pay over $1 billion into this court as a condition of the pursuit of its appeal. That's the second point. The third point, and I don't want to put this too highly. I'm conscious that what Lord Justice Nugee yesterday said about the meaning of the phrase, but I use it for forensic effect. But it's this, that there is an irony here, which is that it's Crescent who effectively kept its application for permission to appeal up its sleeve, only to be deployed after its strategy of trying to shut down my client's appeal had failed.
Can I just ask you about that? I mean, this is on the assumption that Section 67(4) doesn't apply, so that the normal position applies, which is you can ask the judge below for permission, but you can also ask the Court of Appeal for permission, either if the judge below refuses it, or if for whatever reason you have failed to ask the judge below. But there's no general principle, is there, that you ought to apply to a judge below, and if you don't, that's a relevant consideration for this court in deciding whether to grant permission to appeal, or is there a general principle?
My Lord, actually, I think if I may say so, that what your Lordship said may not be quite right. Perhaps I could just show you.
I think there's an encouragement
Well, I think
to
there's a
apply
little bit
below,
more than that.
but is it a relevant consideration for us?
I think it is, for two reasons. One of what Mr. Justice Mead said in the case I'm about to show you, and the second is the point my Lord Justice made in his order of the 28th of February.
That it's helpful to know what...
Which we looked at before, but can I just mention a case called Kirby and Baker?
Yes.
Not necessarily on everybody's radar, but it does touch upon a point my Lord Justice Nugee just raised. And I think it's in Volume 2 of the Bundle of Authorities, tab 28. It's the last tab, Bundle 2. It's a decision of Mr. Justice Mead in November of 2020. And paragraph 9, which says at the top of page 664 of the bundle, here the court means the High Court, and we know obviously that's not controversial. So, he continues, quote, so if permission to appeal were to be sought, it would have to have been sought from me. Mr. O'Sullivan candidly and very properly accepts that he simply overlooked this. And then it's the next bit, my Lord, which is possibly relevant to your Lordship's question. However, I must say that even if permission could be sought from the Court of Appeal, it would not be entirely satisfactory to seek permission from it first, without seeking permission from me, which is the usual and recommended course. The reason particularly applicable where the route to appeal depends on there being a question of general importance or some other special reason, is that the judge in the lower court may be able to provide information and context that would later be useful to the Court of Appeal. So, I don't want to take this too far, my Lord. It goes to discretion. All I would say is what Lord Justice Males, my Lord Justice Males said in his order of the 28th of February, chimes with what Mr. Justice Mead said in Kirkby and Baker, and therefore it is relevant, we would respectfully submit, that Crescent adopted the strategy it did, and as a consequence, this court is left in the position where they don't have anything from Mr. Justice Butcher explaining why either permission should be refused or otherwise. So it goes to discretion, that's what I would submit. The third point, which we make that's relevant to the application, is this, that we do say that it's not an appropriate case in any event, even if you did have jurisdiction, for permission to appeal to be granted. And the reason we say that, and the point I'm about to make, is essentially a summary of my case on the merits of my own friend's putative appeal. And it's this, that in our respectful submission, the judge's judgment in relation to the preliminary issue was careful, considered, and correct. Three very short points on that. And they are, we've set out our written submissions in answer to my own friend's 6 grounds of appeal in our supplemental skeleton, which I'm sure you would have seen, but the relevant reference to the paragraphs dealing with the merits are Core Bundle 1 at tab 6, pages 96.1 to 96.25. That's the first point. And what we say is that none of the criticisms my own friends make of the judgment below have any merit. And what we mean by that, and this is the third point, what we ultimately submit, this is my case, I'll try to build on it in a moment, but what we submit is that the judge identified and applied the correct legal principles, and in our respectful submission he came to the right answer for the right reasons. And for all of those reasons, the 3 submissions I've made on jurisdiction, on discretion, and on the test, we would respectfully submit that the application for permission to appeal should fail and be dismissed. So what I'm going
Can I ask you another question? I'm sorry.
Yes, of course.
This rises out of your submission that what they should have done is applied below first. The test for this court granting permission to appeal, it's a first appeal, so the test is found in 52.6, which is permission to appeal may be given only where the court considers that the appeal would have a real prospect of success or there's some other compelling reason. And my question is this: if we were to conclude, contrary to your last submission, there was a real prospect of success, could we nevertheless say, as a matter of discretion, because you didn't apply below, we're going to refuse permission? Or does it really follow as a matter of course that if there's a real prospect of success, we ought, save in very unusual circumstances, to grant permission?
Well, my lord, the first answer to your lordship's question is the way your lordship postulated the point. The answer is not necessarily. In other words, it would depend very much on the reason why permission had not been sought from the judge below. It can't be right, as your lordship says, to say in every case, if permission is not sought from the judge below, that necessarily means we shouldn't exercise our discretion if we think there is reasonable prospects of success. Of course, that's right. The point I was trying to make was based upon the context of the facts of this particular case, and it was the sophistication of the party concerned, the number of occasions when permission could have been sought, and the strategy that was being adopted, and the irony about the conceptual notion of keeping points up one's sleeve, and how in fact that could well be the way to describe what Crescent did here. That was the point I was trying to make. And it's only because of that colour, if you like, that feeds into your discretion that it's a relevant consideration here. I certainly don't say, and I wouldn't want to be thought to be saying, that in every case it's a powerful factor that goes to discretion that there hasn't been an application to the judge below. I wouldn't put it that high, if I may say so. I hope that's an answer.
Thank you.
So, my lord, can I then turn or make some further submissions on why the cross appeal, even if permission had been granted for it, would fail on its merits? And obviously you've got our written submissions on the merits of the cross appeal. And I'm not going to, although I adopt them, I'm not going to repeat them this morning.
Sorry, just to go back a bit, thinking out loud a bit. If the Court of Appeal has jurisdiction, and if the only test when it gets to the Court of Appeal is real prospect of success, which is recognised to be a low hurdle, that would mean that in arbitration appeals, which are not the final decision under section 67 or 68, it's actually quite easy to get to the Court of Appeal, which is a bit surprising in view of the general policy of finality and the particular hurdle in section 69(8), which might suggest a rethink on whether actually the court is intended to have jurisdiction.
Well, my lord, that's a very fair point, and I'm sure you'll reflect upon it, and you will have to consider whether it's a point in my favour or against me. What I'm submitting, in fact, is it's a point in my favour. And the reason I say that is because, given the test is so, well, I wouldn't say so low, but lower than, say, what would happen if you had to show a point of general public importance or so on. That would be a further reason why case management and decisions along the way would be caught, or Parliament would have intended those to be caught by the prohibition.
Yes.
The point of general public importance, that's the special reason under section 69.
My lord, that's right, and I can't quite remember off the top of my head what if anything, is said in relation to section 68.
There's in the other sections of the Act, there's nothing equivalent to that.
So presumably, under section 67(4) and section 68(4), the lower court should apply the ordinary first appeals test, should it? Of real prospect of success, or should it apply some other criterion?
Well, my lord, there is a nuanced answer, if I may, to that point. But the headline answer is yes, that is the test. The reason for the nuance is because it is being applied by the Court of First Instance in the context of, we would submit an arbitration claim brought under the supervisory jurisdiction of the English High Court, pursuant to its jurisdiction under the Arbitration Act. And in that context, the principles and policies, part of which we've seen in paragraph 1 or section 1 of the Act, but are also reflected elsewhere, section 33 and so on, about the need for expedition, finality and so on. They would feed into, I don't want to put again this too high, but they are part of the context we would submit.
So
feed into the discretion, because it's a discretion at the end of the day.
But that discretion is, to the extent that there is a decision the Court of Appeal has to make, that is potentially relevant to its discretion as well. That context,
Yes.
the arbitration context.
My lady, absolutely. I think that is
relevant.
right to say that the test is the test. It's still going to be the one articulated in the CPR, but the context feeds into discretion. Perhaps I can put it that way.
But it's not, even though it goes award, High Court, Court of Appeal, it's not in any sense a second appeal, or specifically under section 67. It's common ground that the court starts again. It's not reviewing the tribunal's decision on jurisdiction,
Right.
because although it's got competence, in the end it's a question for the court whether it's got jurisdiction or
Right.
not. So it is a true first appeal from the commercial court to
Right.
this court.
Definitely.
But you still say that the court should be slightly more reluctant to grant permission, given the culture of the Arbitration Act.
I think that's I think that's a fair way. I mean, my Lord, Justice Mell would have dealt with many applications in relation to arbitrations,
Yes.
and will be very experienced in knowing exactly what criteria pass his mind when he's exercising his discretion. But I would respectfully submit that the context of it being an arbitration claim does feed into the way in which the exercise of discretion takes place. But I don't want to put it too high. I hope it's an important answer.
Thank you.
So going then to the merits of my learned friend's argument, what I'm going to try and do in the time I have available is address the merits of the putative cross appeal by reference to 3 topics. And the topics I propose to address are as follows. The first of which is why the judge was right to amend subparagraph 7 of his summary of the legal principles at paragraph 36 of his judgment to delete any reference to the decision of Mr. Justice Field in Concola Copper Mines. That's the first topic. The second topic is why the judge was right to conclude that the principle of fairness and openness did not require NEOC to say any more than it did in the arbitration to avoid losing its right to object pursuant to section 73. And then the third topic is why the judge was right to conclude that NEOC has done enough, or did enough, to raise its ground of objection in its submissions for the tribunal. So those are the three topics. And I'm going to, obviously it's maybe some overlap, but I'm going to try and structure my remarks by reference to each of them, beginning, if I may, with the Concola point. Now, before I deal with that, there is an important anterior point to be made. This is relevant to the merits, but it's also possibly relevant to your Lordship's discretion. And it's this: the principal, if not the only, criticism that my learned friend made yesterday in his oral submissions of the judge's exposition of the relevant legal principles set out in paragraph 36 of his judgment was that the judge was wrong to reformulate subparagraph 7 to delete the reference to Concola. Your Lordships will remember paragraph 36 of the learned judge's judgment, where he says in paragraph 36, like the arguments, I would respectfully propose to modify the summary slightly, and over the page at 125 of bundle 1, core bundle 1, you'll see that subparagraph 7 has been amended, and that the reference to Concola has been deleted. So, the anterior point is this: that the submission that my known friend made yesterday came as a complete surprise to me and to those behind me. And the reason for this, not that I've not heard it before, I heard it at first instance. The reason I say it came as a complete surprise is because there's no mention of it anywhere in Crescent's grounds of appeal, and there's no mention of it in their skeleton argument for this appeal. And the fact that the Concola point did not resurface again until yesterday afternoon explains why, despite we've got 5 bundles of authorities, 70 tabs, despite that, a copy of the decision of Concola was not included in the bundle of authorities prepared for this appeal. Now, what's the relevance of that? It possibly goes to discretion, but the reality is it's an afterthought. It's an afterthought, and for the reasons given by the learned judge, we submit the Concola point is a bad one at that. Now, to make that good, my lords, perhaps I can explain in substance why it's a bad point. And the judge explained the reasons why he amended subparagraph 7 and deleted any reference to Concola at paragraphs 34 and 35 of his judgment. And obviously I'll ask your Lordships, I'm sure you and my lady, to read those, and I'm sure you will. But what he did, in my respectful submission, was give effectively 3 reasons in paragraph 34 as to why it was appropriate to delete any reference to the dictum taken from the judgment in Concola. And the first of those reasons was that the Concola case, which I hope you've now received a copy of, or at least if not, we can provide copies of. But, it certainly will be provided to the court.
I've got a printout of it. Is it reported anywhere, or is it simply the new citation?
My lord, it's not been reported.
No, okay.
What the Concola case was addressing, we would submit, is a completely different issue, namely the application or an application to amend an existing arbitration claim form after it had been issued and after the expiry of 28 days from the date of the award, which is, I'm sure the court will know, is the guillotine date. And what we would respectfully submit is that the learned judge, Mr. Justice Butcher, was entirely right to say that the comments made by Mr. Justice Field in that case were made in a wholly different context from section 73 and in circumstances where wholly different considerations apply. That's the first reason. The second reason that the judge gave, this really runs into what he says at the top of page 124 of core bundle 1, second part of paragraph 34 of his judgment. The second reason the judge gave was that importing what Mr. Justice Field had said in Concola into the rubric of Section 73 was inconsistent with Mr. Justice Hamlin's, as he then was, decision in Habas. And again, we would respectfully submit that that was correct too. And the third reason that the learned judge gave as to why it was appropriate to delete Concola is because the dictum of Mr. Justice Field in the context of an application to amend a claim form, if applied in the context of Section 73, was also inconsistent with what Mr. Justice Andrew Smith had said in Arsenovia and Cruz City. And again, we would respectfully submit that was also correct. And there's a fourth reason, which the judge didn't give, but which I will add if I respectfully may, which is this, that, and the judge could have given this reason, which is that it would also be inconsistent with what Mr. Justice Aikins, as he then was, had said in prime trade. Because what, as we know, Mr. Justice Aikins had said in prime trade, and we see this from subparagraph 6 of the principles, which are set out at page 125, which my own friend does not quibble, which is that, quote, the grounds of objection should not be examined closely as if a pleading, but broadly, or adopting a broad approach. Now, we would respectfully submit that the formulation of paragraph or subparagraph 7 by Mr. Justice Robin Knowles set was inconsistent with the principle expounded by Mr. Justice Aikins in subparagraph 6. So that's the fourth reason we would submit, to add to those given by the judge as to why his amendment was correct.
So is there a difference between the judge's formulation that the substance of each ground of objection should have been communicated, and Mr. Justice Knowles' formulation that the specific grounds which are to be advanced should be communicated?
Well, my lord, your lordship is right to focus on that point, and obviously your lordship asked the very same question to the learned friend yesterday. Your lordship spotted quite rightly that what the learned judge below had done was to reformulate the principle at subparagraph 7, and he reformulated it so as to provide that the party challenging the jurisdiction of the tribunal had to have communicated the substance of the ground of objection relied upon. And your lordship said, I think your lordship asked my own friend, where did that formulation come from? And to which my learned friend said, it came from the judge, but it was a little too narrow. I haven't got the transcript reference, but I did read it in the transcript. That's what he said in answer to my Lord Justice Nugee's question. Now, I have 2 points on that. The first is this, that in a sense, it's entirely correct to say that it came from the judge, Mr. Justice Butcher, and the reason is because it's set out in his judgment at paragraph 35. However, the criticism that that formulation is too narrow is, in my respectful submission, unfair. And it's particularly unfair coming from Crescent. And I say that because the reason, or rather the source, of the proposition which Mr. Justice Butcher articulated was the submissions made by Crescent themselves. And what I have in mind, for example, is if you look at the transcript of the hearing below, I think it's in supplemental bundle 4. I think if we go to page 1405 of the bundle, these are my, and obviously I'm not cherry picking, and I certainly encourage you to read it in context. But what my learned friends are addressing here is the submissions made by NEOC, on which we relied, of course, and which in the end proved significant, paragraph 117, if you remember. And what I'm pointing to is what is said on page 53 of the internal pagination of the transcript. And or perhaps I can pick it up at line 7. This is a submission by my learned friend. If we then turn to the further elaboration, paragraph 113 onwards, you will now see it's a split between rationae personae and rationae materiae. But we obviously have to look at the substance of what is being said to understand what they mean by that. Now that, we would submit, is a source, or at least chimes with exactly the way in which the learned judge ultimately formulated the test, namely that one has to look to see what the substance of each ground of objection that was made before the tribunal. So, my Lord, with respect, the criticism that is now advanced that the learned judge went wrong as a matter of law in articulating the relevant principles applicable to the application of section 73 is, without, in our respectful submission, without merit. Now, the more interesting, in a purely objective sense, topic is this, namely, how does the principle of fairness and openness fit into all of this? And our submission here, well, and even if it sounds initially counterintuitive, I'll explain why that's not the case. Our submission here is that the principle of fairness and openness did not require NEOC to say any more than it did to avoid losing its statutory right to challenge the jurisdiction of the tribunal under section 67. Now, there are two introductory points which are key here to unlocking the door to the proper analysis. The first key point is this, that the level of granularity or specificity required by section 73 is a product of the compromise between two competing principles. And this is explained in paragraph 26 of the learned judge's judgment. First sentence, paragraph 26. Section 73 of the 1996 Act embodies a compromise between different principles. And the two, let's read the whole paragraph, it's important, but the two competing principles are these. Firstly, the absolute unfettered right of a party to challenge a decision by the arbitrators as to their jurisdiction. And competing against that, and, to have a full rehearing, call as much the evidence, we can look at what that means, but in other words, first principle is that a party challenging the arbitrator's decision as to their jurisdiction has an absolute right, described by Lord Collins as a fundamental right, for a complete independent rehearing de novo of the jurisdictional point. Which in other words means they could, in theory, argue whatever they liked, produce whatever evidence they liked, effectively have a completely fresh start. So that's one competing principle. And put against that is the principle of fairness, which dictates that a party who has an objection to the jurisdiction should raise it in the arbitration and not keep it in reserve or keep it up its sleeve, as has been said in certain contexts, for a challenge in court. That's they're the two principles that collide.
Well, the second principle goes a little bit further because the judge talks about arbitrators having competence to rule on their jurisdiction, and he refers to section 30, and also 31 gives them the right to make an award as to jurisdiction, either when the point is taken or later, or alternatively to send it off to the court. And section 73(2) itself talks about not objecting later on any ground which was the subject of the arbitrator's ruling, if you don't do so promptly. Now, doesn't all that suggest that whatever else, a ground has got to be articulated sufficiently so that the arbitrators can deal with it? In other words, they know what it is and can say yay or nay.
Well, that's a fundamental point, and there's a huge answer to that, which I will try to elaborate upon. But the
Yes.
answer is, in my respect for submission, no, but I'll try and explain why.
No, that's fine.
But the reason is, in practical terms, the objection has to be raised, certainly. And then the question becomes, how is it case managed by the tribunal? Quite accept that. Tribunals see it and think to themselves, well, gosh, what am I going to do about that? They can ask questions, what do you mean by that? How are we going to deal with it? So it certainly needs to be case managed. Totally see that.
But if you're right, and NEOC has done enough by saying something which the arbitrators don't understand and can't deal with, NEOC doesn't have to answer that question. The arbitrators say, what do you mean by that? And NEOC says, I'm not going to tell you. I've told enough, I've said enough to preserve my Section 73 rights, and that's it.
Well, my lord, that if I have to say, that would be, if a party was asked, what do you mean by that, say, I'm not going to tell you, that seems to me would be directly contrary to what the DAC say in their guidance as to what Section 73 is intended to deal with. That's not this case, we respectfully submit. That would be an extreme case. What, as I'll come on to explain, what Section 73 is a compromise between two competing principles, namely the right to a de novo determination of jurisdiction, irrespective of whatever the tribunal had said or done about it at all, in terms of management or decision or otherwise. Totally unfettered on the one hand, and that has to be balanced against the point that it would be unfair for a party to keep an objection to jurisdiction up their sleeve so as to basically ride two horses at once. Take the award, if they've won, keep quiet, if they've lost, pop up with a little card saying, we've got a jurisdictional objection. That's the essence of what Section 73 is designed to deal with. And the point I'm making is, and this is the dilemma, this is the point, heart of the case. The dilemma is this: putting those two principles against one another. Where is the balance to be struck in identifying the level of granularity required for the purpose of communicating the substance of each ground of objection being relied upon? And what we respectfully submit, and I'll try and explain why, if anything, why the bloody judge is actually more generous to Crescent than we would perhaps submit is the case, but why we submit that the balance that was struck by the learned judge was correct in the way in which he formulated what the requirement was. What my learned friend's case ultimately amounts to is a submission that he made yesterday that the judge struck the balance too generously to the objecting party, too generously to my client, and that fairness requires that the objecting party should have specifically identified his ground of objection in the reference so that the other party can deal with it and the tribunal can rule on it. That's how he puts it. It's so superficially attractive, which it is. But it doesn't tell the right story. And the reason it doesn't tell the right story is because what we're dealing with is identifying what fairness requires in the context of a melting pot of consideration, some which point one way and some which point the other. Now, I need to make these important points. We submit that there are four countervailing considerations beyond that which the learned judge will obviously identified. It's important I'm sure you will take that into account. The key countervailing consideration is the one he identified in paragraph 27 by reference to what Mr. Justice Thomas said in Joanna V about the nature of a rehearing and the fact it's totally unfettered, it's an absolute right and so on. That's obviously the key countervailing consideration, namely that Section 73 should do no more than is absolutely necessary to erode upon that basic right. That's the main consideration. But there are four more considerations which we respectfully submit should be brought into the balancing inquiry as to where the compromise is to be struck as to the level of granularity required. And the first of those is this: that on the natural reading of Section 73, all that is required is that a party objecting to the tribunal's jurisdiction only has to raise the objection itself to avoid being lost. And perhaps just, I'm sure this is in your minds, but if I just ask you, just to see what I mean, but to look again at what Section 67 says, sorry, Section 73 says, I beg your pardon. It's in Bundle 5 of the authorities at page 1317, loss of the right to object. If a party to arbitral proceedings takes part or continues to take part in the proceedings without making either forthwith or within such time as is allowed by the arbitration agreement or the tribunal or by any provision of this part any objection that the tribunal lacks substantive jurisdiction, he may not raise that objection later. And then there's a proviso, but that's after the comma. Now, on the natural reading of that, all that is required is for the party objecting to have raised the objection itself to avoid it being lost. The additional requirement that he has to identify the ground of objection is itself a judicial gloss, first introduced on the grounds of fairness, in other words, by reference to the concept of fairness, by Mr. Justice Coleman in the JSC and Zestafoni case. So, starting point is what the Act says. First point is barometer moved in favour of Crescent and party who asserts jurisdiction by adding this further requirement that not only just do you have to identify the objection, you have to identify the ground of objection as well. That comes out of Mr. Justice Coleman and has been followed in a series of first instance decisions pretty much ever since. One exception, which I'll come on to.
Are you accepting that, or are you inviting us to say that's wrong?
Well, I want to come to that because I don't think you need to, but I'm certainly putting a marker down that well, the marker is this. If you are tempted, which I suggest you shouldn't be, if you are tempted to unravel this whole area of the law, then I will be making a submission that that's wrong. And certainly I'm putting out a marker that, and I'll explain why in a moment.
Well, I'm not sure you can put down a marker. You've either got to advise us to say it's wrong or not.
Well, okay, well, I'm not going to hide. I'll be frank about my position, and I'll come to it. It's a very important point.
Yep.
If you're prepared to, despite the fact that obviously this is an area being looked at by the Law Commission at the moment, if they want to change the law, they can do so. But if you want to re-evaluate the whole of Section 73, what it means, and then I will be making the submission that what Peter MacDonald-Eggers submitted to Mr. Justice Hamblin in the Habas case at paragraph 83 was in fact correct. And I'll come on to that.
But you just need to say, I object to jurisdiction. You don't need to say anything more at all.
You don't need to say any more at all to avoid there being a waiver. Of course you have to do more. Well, I'll come on to this. What we're talking about here is losing a statutory right and what the normal conceptual principles might be. I will come on to that. There's lots to think about here. I'm not ducking the question, my lord. I will promise I'll answer it.
Is it right there's no decision of this court on Section 73 at all?
There's certainly none I'm aware of, so
I don't believe so. That's what I said.
I mean, obviously, we've certainly nothing reported. There's nothing that. There's always a possibility something slipped through the net, but there's no case that we're aware of. But the point I'm making here is that the requirement at all that there should be any form of articulation of the ground of objection is a judicial gloss on the wording of the statute. That's my first point. Now, the second, this is where it gets more profound. The second and most profound countervailing factor, which has been ignored so far, is this, that it's very important to remember that Section 67 can also be invoked by a claimant who wants to challenge a finding by the tribunal that it did not have jurisdiction. In other words, Section 67 isn't all about the party objecting to jurisdiction. Section 67 is about preserving the absolute right of parties to say, whatever the tribunal thinks about its own jurisdiction is irrelevant. The court is the only body that can decide what the jurisdiction of the tribunal is. And therefore, as there are examples in the cases, one of which is the Poland case, which I haven't got time to go to, but I'm very much I like Mr. Justice Bryan's decision, the case my learned friend argued. That was a case where my learned friend had lost in establishing the jurisdiction of the tribunal and challenged that under Section 67. It's very clear. Now, why is that important? Why is the fact that Section 67 allows the party who wants to establish jurisdiction to challenge a decision by the tribunal where it said it didn't have jurisdiction? Well, the reason that's important is because Section 73 only applies to a party who's objecting to the jurisdiction of the tribunal. Now, what that means is that a party who wants to challenge a finding by a tribunal that it did not have jurisdiction is able to have a complete de novo hearing of the type Mr. Justice Thomas described in the Joanna v. of the jurisdictional question by the court, and it can rely on any ground it wants to establish jurisdiction, regardless of whether those grounds were raised before the arbitrator or not, rely on any evidence, any arguments. In other words, the party asserting jurisdiction can completely change horses and is not in any way restrained by Section 73. Second point I want to make is this is not a hypothetical point. And the reason I say that is because I want to show you a case which again is vitally important if you're thinking about opening up this area of the law, which is Dalla, which we haven't looked at in any detail. It's in Authorities Bundle 1 at tab 11. And it's
the
a
point
decision.
you're making, just to be clear, your point you're making follows presumably from the fact that Section 73 is written in the way it is, or put it another way, there's no equivalent to Section 73 covering the scenario that you're talking about.
Well, one needs to see what the DAC report explains what the genesis of 73
Yes,
is.
indeed.
It's to stop recalcitrant parties and those that keeping points up their sleeve. It doesn't apply to
Exactly.
a claimant who's asserting jurisdiction. The significance of that is that when you come to consider what points the party asserting jurisdiction can take in a court, they are not bound in any way by what they said in the arbitration. And we can see that most explicitly by what happened in Dalla, a slightly different context, but it's equally true as I'll explain here. And what I mean is, if you look at Dalla, which is at tab 11 of Authorities Bundle 1, paragraph I want to show you is at page 295, paragraph 11 of the judgment of Lord Mance, where he says the validity of the arbitration agreement depends in the present case upon whether there existed between Dalla and the government any relevant arbitration agreement at all. Dalla's case is that the government has at all times been an unnamed party to the agreement containing the arbitration clause. Before the English courts, this case has been founded on a submission it was the common intention of the parties that the government should be such a party to the agreement. Before the tribunal, Dalla put the matter differently. It argued that either the trust was the alter ego of the government, or the government was the successor to the trust or to the rights and obligations which the trust had under the agreement prior to its demise. Neither of these ways of putting the case is now pursued. And again, if you just look forward to page 307 to 308, Lord Mance returns to this topic, where he talks about the tribunal's conclusion. The tribunal's ultimate conclusion on jurisdiction was thus, which of course it was totally unsustainable because it was not even based on the proper system of law. But anyway, be that as it may, the tribunal's ultimate conclusion on jurisdiction was thus expressed as a finding in which two of the arbitrators only narrowly concurred that the trust was the alter ego of the government, making the government a true party to the agreement. That, as I have said, is not now Dalla's case. But Dalla points to the reasoning, and then he says there's considerable difference between a finding. So I'm reading from the last three lines. Considerable difference between a finding, between the evidence relevant to the finding that one or two of the contracting parties is the alter ego of a third person, and the finding it was the common intention of the other party to the contract that the third person to be a party the contract made with the first party. In other words, Lord Mance is focusing on the fact that the case is very different. Now, appreciate those remarks were made in the context of a challenge, the enforcement of an award that was made under the New York Convention in a separate jurisdiction. But as the speeches or the judgments in Dalla demonstrate, both Lord Collins, Lord Mance, is that the ultimate analysis in relation to jurisdiction is essentially always the same. Namely, that although tribunals have competence jurisdiction to say what they think their jurisdiction is, it is irrelevant to the final conclusion. And going to my third of my 5 points, closer to home, what Lord Mance was articulating is also true in the context of the present Section 67 claim, or indeed any other claim. And what I mean by that is that the so-called principle of fairness and openness does not restrain my learned friends in any way from relying upon any new argument, any evidence, any system of law. If they wanted to say, Mr. Bailey, you're wrong, it's not Iranian law, it's English law, because it's Russian law, they're perfectly entitled to do so. They're entitled to rely on any ground whatsoever, because it's a de novo hearing without restraint, whether communicated to the tribunal or not, to try and persuade this court, in the context of this Section 67 application, that the tribunal was right and that it did have jurisdiction to determine the existence and extent of GCC's liability to CGNC under the third-party contract. It's totally unfettered. And what we submit, the fourth point is this, that the lack of symmetry here is very important in the context of deciding where to strike the balance between what Section 73 requires and the impact it has in fettering the rights of my clients or any other party who wants to challenge a decision by the tribunal that it did have jurisdiction. And what we would submit is it makes it very difficult to say that the principle of fairness and openness between the parties requires an objecting party to do any more than what Mr. Justice Butcher said was required, and in the submission I'm about to make, any more than what the statute actually requires. And what I mean by that is that if, taking back an analogy, perhaps it's a perfectly good one this week with Wimbledon going on, going back to an analogy of Lord Mance in Dalla, it may be fair to say that the party asserting jurisdiction should have the serve, but it's far more difficult to say that they should start 15 or 30 love up, which is what my own friend's case, properly understood, despite its superficial attraction, really amounts to. Now, the third consideration, there's a lot here, but I'll try my best to deal with it in the time I can. The third consideration is this, that just going back and looking at this as a matter of first principle, first jurisprudential principle, the ordinary inquiry to establish that a party has waived a statutory right, certainly one as important as this, namely the right to challenge the jurisdiction of the arbitral tribunal, which, as I say, Lord Collins described as being a fundamental right at the heart of arbitration. Normally, applying ordinary principles, one would expect to have to point to words or conduct which is unequivocal and which is inconsistent with the continuation of the existence of that right. So that's the third consideration to bear in mind when construing what Section 73 is all about, namely a waiver of a statutory right. And the fourth point on fairness, and this goes to the so-called arguments about, oh, the tribunal's got to be able to rule on it, they've got to understand it, Crescent has to understand it so it can make its submissions. All of that is of no, not irrelevant, but it's of no great weight in determining where the balance is to be struck. Particularly in the context of Section 67, I do need to draw a distinction here, but I'm discussing why it's of no great weight in the context of Section 67. And that's because the ruling of the tribunal, in other words, whatever the tribunal says, or whether it goes into great detail or it misunderstands the point, doesn't understand it, Crescent don't give the right submissions, and they may do that for tactical reasons, whatever happens in relation to the objection after it's made, whether the tribunal understood it or not, what they said, is irrelevant. Save for the fact that it may be sufficiently cogent that one of the parties would adopt the reasoning as part of their argument. as a matter of analysis, what the tribunal says has no, in the context of Section 67, it's different from 68, which I'll explain. Section 67 has no legal or evidential weight. And there was a recent decision, I'm sorry this wasn't in the bundle, it was only when I heard my own friend's submissions yesterday this became particularly pertinent. But there's a recent decision of Mr. Justice Andrew Baker in a case called Gold Pool. Again, I don't know whether it was reached your lordships. If not, can I hand it up? It's very short.
Have you got it?
I've got a copy.
I think I've got it on.
Yeah. You seem to be all right.
Very good. Well, it's only two short paragraphs I want to show you, lordships and my lady. They're paragraph 6 and I think 7 and 8. And actually, it refers to the Poland case, which is the decision of Mr. Justice Bryan, which I also alluded to earlier. It's paragraph 7. The nature of Section 67 claim and the approach to be adopted by the court requires no substantial elaboration on this occasion. It involves and requires a rehearing de novo by the court, in which the arbitrator's conclusions have no legal or evidential weight. I agree with the explanation of the position of Mr. Justice Bryan in the Poland case, and I would, if I had time, take you to it, but I would invite you to follow those references up. It has been, sorry, that's not part of the quote for the transcriber. Back to the quote. It has been said that nonetheless the arbitrator's conclusions and reasons may be of interest, rather more often than it is being explained why that might be so. For example, in Dalla, Lord Savile, no less, said that the findings of fact may be the arbitrators and their view of the law can in no sense bind the court. So, of course, the court may find it useful to see how the arbitrators dealt with the question, without explaining why. The court might find it useful to look at conclusions that have neither legal nor evidential weight before it. And then there's actually a reference to another decision of Mr. Justice Butcher, where Mr. Justice Butcher said that he quite liked the idea of looking at the reasons of the tribunal. If and to the extent the reasoning is persuasive, then there's no reason why the court should not be persuaded by it. And Mr. Justice Baker says that idea needs to be applied with a degree of caution, however, as the court's task is to decide the case as presented to it by a party on the rehearing, as Mr. Justice Bryan explained in GPF versus Poland. It should generally be for the parties to decide for themselves to what extent they each may wish to adopt the reasoning of the arbitrators as an argument of their own in court. In short, Section 67 does not operate by way of a review of the arbitrator's decision. Now, my respectful submission, the way Mr. Justice Andrew Baker put it, perhaps a little bluntly, but how he put it is absolutely analytically precise and right. That's a relevant consideration in the context of these arguments about, oh, what the Crescent didn't understand it, the Tribunal didn't understand it. It really doesn't matter, because what they say is irrelevant. Now, the gloss I want to add, which is a very important one, is that in the context of Section 68, it's different. And the reason it's different, and why fairness may require a lot more particularity in what you say in order to avoid your right to object, is because in Section 68 context, the tribunal can correct the irregularity as you go along. You can't create jurisdiction that doesn't exist. It's a historical fact, it's there or not. Irregularities under Section 68 are very different, because things could be happening in the course of the arbitration that could be dealt with. And it's very important, therefore, if there is an objection, it's articulated with sufficient precision that the tribunal can, and the other side, know exactly what it is, so it can be dealt with. Because if it's not, there could be a real injustice, because there would have been an opportunity to remedy the irregularity if the objection had been properly articulated, which is lost.
Well, that may apply under Section 67, because one of the questions is whether the tribunal is properly constituted. Another is what matters have been submitted to arbitration in accordance with the arbitration agreement, and if those points are made, they can be corrected before it's too late and some limitation period goes by.
Well, maybe if that is right, and one needs to then look at the nature of the rejection being taken. The question here is one of substantive jurisdiction within the meaning of Section 31C of the Arbitration Act, and in this particular context, we are simply talking about a historical issue. Does the tribunal have jurisdiction within the scope on the true construction or the scope of the arbitration agreement to decide a particular issue or claim? And that's got a universal answer to it, which can't change.
I mean, I appreciate that your case here is that the liability to CMCG claim can't be submitted to arbitration because of the limited scope of the arbitration clause, and there is nothing that can be done about that.
Yeah.
But nevertheless, there are aspects of substantive jurisdiction which can be corrected, seems to me at any rate, and therefore the bright line distinction between section 67 and 68 that
May not be right.
drawing is,
My lord,
is at least blurred.
I think, in fairness, your lordship's right. I haven't thought about the way in which it might apply, but the conceptual distinction I'm seeking to draw is still a valid one in my respectful suspicion. The conceptual distinction is that if and insofar as it's possible for the objection or the irregularity or the deficiency in the appointment procedure getting a signature from the ICC or whatever it may be, if it's possible that if the objection is not properly articulated, the opportunity to remedy the deficiency is not available, that is going to be a very considerable consideration in deciding what the level of granularity section 73 requires to preserve the point going forward. I accept that. And the submission I was trying to make is that certainly in the context of section 68, one has to be more conscious of that because there's more obvious examples of how an irregularity may occur that, if not identified with sufficient precision, cannot be remedied. And that's the point I was trying to make. But I take your lordship's
I mean, there are equally some section 68 objections which can't be objected, can't be corrected.
True.
You've appointed an arbitrator who is too closely connected to one of the parties, for example.
Quite, my lord. That's absolutely a point that's of historical and can't be changed. Yeah. What I suppose this means is that one may have to look at the facts very carefully of every case, but what it does mean is that my own friend's submission that fairness dictates this high level of specificity that he articulates for the purpose of 73 is, my submission, not borne out, at least in cases where there's no opportunity to deal with or remedy the deficiency at the time. Now, going back to the point my Lord Justice Mayo has asked me to now my question and ask, I've taken you through, as quickly as I can, all those countervailing considerations which we say have to go into the melting pot if you are to re-examine where to strike the balance between the various competing considerations in identifying how to articulate the test of the level of granularity required for the purpose of articulating your objection before the tribunal in order to avoid having lost it for all time. Now, what we say is that we are content to accept that the judge struck the correct balance, and there's a body of first instance jurisprudence which has been summarised in the Pakistan case and also in Justice Butcher's case, which is consistent with that approach that Mr. Justice Butcher adopted. However, what we would submit is if the court is minded to grant permission to appeal and is minded or tempted to re-examine and reconfigurate the relevant principles, then given the submissions that my own friend raised yesterday, our case would be, and certainly as I say would be if we go further, is that the submission that Mr. Peter MacDonald Eggers made for Mr. Justice Hamlin, as he then was correct. And I just give you the reference to that. It's in Authorities Bundle 2 at tab 20. And it's the section that begins at page 555, and it's on the left-hand column. It comes under the heading 1, which is underlined, whether and if so, to what extent Habas has lost the right to object to the tribunal's jurisdiction. And paragraph 81, at the arbitration, no reliance was placed by Habas on matters of Turkish law. The SC contends that Habas's contention in these proceedings that the issue of authority to enter into the arbitration agreement is governed by Turkish law, and that there was no requisite authority, constitutes a new ground of objection to jurisdiction which is not open to Habas to make. Further, alternatively, VSC contends that Habas's case that there was no valid arbitration agreement because of the formal requirements of Turkish law for making such an agreement were not met, as this is a new ground which is not open to it. And then there's reference to section 73. Then in paragraph 84 to onwards, there's reference by the learned judge to those cases which we've looked at. The Ethan, which is the prime tape case, the Zestafoni case, and so on. And in particular, in 84, he refers to the fact that the term, quote, any objection in section 73.1 was intended to mean, apparently, any ground of objection, close quotation marks. Now, and then paragraph 85 is the point. Habas challenges this interpretation of section 73. It submits, and this is Mr. McDonald-Eggers' submission, it submits that what is required is that an objection to jurisdiction is made. Provided such an objection is made, there is no loss of the right to object. To require the objection to be made upon the ground relied upon is an unduly prescriptive and involves reading words into section 73. Now, Mr. Justice Hamblin, at least at first instance and possibly in a future situation as well, says, I do not agree. I respectfully consider the approach of Mr. Justice Coleman and Mr. Justice Aikins, as he then was, to be consistent with both the wording of section 73, the intention behind it, and the policy of finality reflected in the 1996 Act. In order to decide whether a new ground of objection has been raised, the grounds of objection should not be examined closely, as if a pleading, but broadly. The fact that it raises different and broader arguments or new evidence does not mean that it's a new ground. Well, as I say, given, and perhaps it's to be looked at as a sliding scale, in the sense that you can have perfect precision in the way in which you articulate a point, or you can just simply make the point. And what, at the end of the day, we're concerned with is where on this scale do you stop the meter and say this is the level of granularity or specificity that is required in order to ensure that you haven't lost your statutory right to object. And what we submit, for all the reasons I've identified, and particularly the fact that fairness is in the context of a level playing field, the fact there is no restrictions at all on the party alleging that a tribunal has jurisdiction, that's a very important point. Fairness and level playing fields and openness, putting all that together, my respectful submission, the proper, as a matter of pure analysis, Mr. McDonald-Eggers was right in his submission, my respectful submission, but on any view, even if Mr. Justice Butcher was right, where he decided the level of granularity lie, namely the need to communicate the substance of the point, that certainly shouldn't go any further than that in my learned friend's direction. That's my submission.
So if you're right on striking the balance, then this more extreme submission, if you don't mind me calling it that, doesn't arise.
It's very much an alternative submission.
But if it does, is your submission then that it is sufficient to say we object because you don't have substantive jurisdiction, full stop, or are you required to go on and identify at least which of the categories in section 30 applies? And if so, is that the end of it?
Well, that's a very fair question, and I do want to give you the answer, but I'm just struggling to remember the reference to the page I want to show you. But if you give me a moment.
Yep.
Oh, well, I'm terribly sorry, I'm wasting time. It's what I was looking for, and I think we've seen this before. And I think probably this is as good an example as what I was trying to get at, so forgive me if I've not got exactly the passage I have in mind, but this demonstrates the point I'm making. It's page 486 of tab 4 of Supplemental Bundle 2. And 486, this is under the section called Overview of my client's first main submissions to the tribunal, and it's paragraph 23 at page 486. Now, my alternative submission will be, if necessary, we would submit that paragraph 23 is sufficient. What is contained within that paragraph is sufficient to preserve our statutory right to ask the court to determine whether or not that is true. What we've said there is that the claimants are asking this tribunal to determine the existence of CGC's liability to CNGC and its extent. Yet it is obvious that this tribunal has no jurisdiction to do this. Now, we can unpack that. In fact, there's a lot more we can look at, we will look at. Indeed, the learned judge looked at. But my submission would be that that paragraph is enough to avoid a waiver taking place. From a normal waiver perspective, I mean, we look at what does waiver mean? See, the idea that that's an unequivocal statement or inconsistent with us having abandoned the statutory right to take that point to court, it is remarkable as a matter of basic jurisprudential principle. But as I say, I don't need to go that far, but if I need to, that is my submission.
Okay, that's very helpful, thank you.
My Lord...
I couldn't quite understand if that was an answer to my Lord's question, which is that if Mr. MacDonald-Eggers was right, is it enough to say, I object to jurisdiction? Do you have to say, there are 3 grounds of objecting to substantive jurisdiction in Section 30, and I'm going for Section 31A or 1B or 1C? Or do you have to do what you say you've done in paragraph 23 of your overview, which is to say, what I say about substantive jurisdictions, you don't have jurisdiction to deal with the existence and effect of the contract between CGC and CNGC, which is clearly much more detailed than simply saying I object to jurisdiction.
No, my Lord, that's a very fair point, and of course, in a sense, I don't mean to duck it, but I know now you've mentioned it, I can see how you think I might have done. The way I sought to answer it is say, well, look, here's a precise example of what we say is enough.
You say that's enough,
Yeah.
but that
then your question is, well, how do you define conceptually what is the...
the actual question was, is it enough to say I object to jurisdiction? I mean, if we are being asked to, which I'm not sure we are, but if we are being asked to re-examine and reconsider the whole of Section 73, what do you say the answer? How far do you have to go?
Well, that obviously is the issue at the very heart of the merits of the appeal if it were to be pursued, allowed to be pursued. Where do we say it goes? Well, the objection has to have been made, that's for sure.
I think Mr. MacDonald-Eggers would have said it's enough to say you don't have substantive jurisdiction.
Well, I think that is right. You do not have substantive jurisdiction, but you may have to say over what.
Yes.
But beyond that, maybe the other way of looking at it is look down the other end of the telescope and say, what do you have to avoid saying in order not to lose your right to object? I haven't thought of it that way before, but I just raised that for you, perhaps reflection.
Can I ask you, if you look at Section 73, what we're construing, I think, is the words, he may not raise that objection.
Quite.
And so the question is, what does that objection mean? Is it enough to say my objection is,
well, it is enough.
You lack substantive jurisdiction, or does it have to go further?
Well, on the strict reading of the Act, all you have to say is, I object that the tribunal that lacks substantive jurisdiction. Once you've said that, that's sufficient on the pure reading of the Act.
Well, can we look at B? Proceedings have been improperly conducted, or D, there's been any other irregularity. If you were trying to maintain those, which would be Section 68 challenges, I think, would it be enough to say the proceedings have been improperly conducted? I mean, that doesn't give any hint at all as to what your ground for the objection is, because, as we know, there are all sorts of ways in which serious irregularities can be committed, and they're listed in Section 68.
Well, quite, my lord. I totally accept that, which is why I did try to acknowledge without being prompted that there is potential difference when you come to Section 68, because there are ways of remedying errors or improper conduct. It may be capable of being remedied.
But that means that as a matter of language, it's the same words, that objection. In the case of Section 68, it does have to go further than say,
Well, that's,
I have an objection that the proceedings are being improperly conducted, but I'm not going to tell you what it is.
but that's why I use the analogy or the metaphor of a sliding scale, because when you interpret Section 73 in various different contexts, you might find that the meter actually falls at a different point. And I do acknowledge and indeed submit that a greater level of granularity is required if one is seeking to make an objection that proceedings are being conducted improperly, so as to ensure that you're not basically hiding a point up your sleeve. You have to articulate the point.
You have to
so
say
it can be
what's improper.
what's improper.
And
But
if we
there is
look at Section 68, we've got a list of things which...
But there is
could be
there is a major difference here, which is that Section 67 goes to the very essence of the arbitral procedure, the question of consent to arbitrate. So that level, as Lord Collins said, it's of a fundamental nature, and to lose that right, it would be a dramatic consequence. That's, I suppose, my point. I can't answer, and I don't think, and the reason I can't answer is because I can't contemplate all the possible scenarios that might arise. So I can't say that there's one test as to granularity that applies to Section 73 in all circumstances, and I, in fact, positively submit there isn't.
You can preserve your rights to take any point you like completely unfettered if you don't take part in the arbitration, Section 72.
True.
But the deal is, if you do take part, then you've got to descend to some extent, and the question is how far.
I'm going to make, since this is of interest to you, Lordships, since you've raised the point, and since I have now made the submission, I do want to show you one paragraph which I rely upon in the judgment of Lord Justice Lord Mance in Dalla, because it touches on this very point. It's in Authorities Bundle 1, I believe.
1 to 11.
1%. And it's a paragraph I'd ask you to bear in mind if you are considering this. It goes to the point my Lord Justice Males made a moment ago. Have a look. The paragraph I have in mind is paragraph 26 on page 302. And probably we need to read 24 first, actually, on page 301, where Lord Mance's Dalla's stance on question B cannot be accepted. Arbitration of the kind with which this appeal is concerned is consensual. The manifestation of parties' choice to submit present or future issues between them to arbitration. Arbitrators, like many other decision-making bodies, may from time to time find themselves faced with challenges to their role or power, and have in that event to consider the existence and extent of their authority to decide particular issues involving particular persons. But absent specific authority to do this, they cannot, by their own decision on such matters, create or extend the authority conferred upon them. And then there's some comparative reference to other areas where there's competence. And he returns to the point in paragraph 25, leaving aside the rare case of an agreement to submit the question of arbitrability to the tribunal itself. And what he means by that is where effectively you've conferred on the tribunal the authority to make the final decision as to their jurisdiction, which he quite rightly describes as rare. In fact, I have never come across in my life such an agreement, but obviously it's possible something could emerge of that type. But anyway, leaving that aside, he then goes on, the concept of competence is applied in slightly different ways around the world, but it says nothing about judicial review, and it appears that every country adhering to the competence principle allows some form of judicial review of the arbitrator's jurisdictional decision. And then he cites from United States authority, and over the page he refers to English law, and he cites from a passage from Mr. Justice Devlin's judgment, who then was in the Christopher Brown case from the 1950s, and which he then says coincides with the position in France. But then it's paragraph 26, which I particularly invite you to consider. An arbitral tribunal's decision as to the existence of its own jurisdiction cannot therefore bind a party who has not submitted the question of arbitrability to the tribunal. This leaves for consideration the nature of the exercise which a court should undertake, where there has been no such submission and the court is asked to enforce an award. Domestically, there is no doubt that whether or not a party's challenge to the jurisdiction has been raised, and that's the key point, whether or not a party's challenge to the jurisdiction has been raised, argued and decided before the arbitrator, the party who has not submitted to the arbitrator's jurisdiction is entitled to a full determination on evidence of an issue of jurisdiction before the English court, and an application made in time for that purpose under section 67, just as he would be entitled under section 72 if he had not taken part before the arbitrator. Now, what Lord Mance goes on to talk about is this tennis analogy and how many points you should have if you've got the serve. But on the face of it, very difficult to reconcile what Lord Mance has said there with what my lady friend's submissions about specifics, about pleadings, and he wants all the details and all the stuff, all the points he was making about how far the pendulum should swing in his favour. It's very difficult to square that. And I would adopt that, my lord, and say, obviously, against that there is a possible waiver, and we know that because of section 73.
It's quite difficult to reconcile that with section 73 at all, isn't it?
Well, my lord,
Does
no, because whether or not the party's challenge to the jurisdiction has been raised, all you have to do to satisfy section 73 is say, I object to the jurisdiction.
you don't need to argue it. You don't need to have it decided.
Quite.
If you do have it decided, you're then into section 73(2), and something which the tribunal has ruled on, you then can't raise again unless you do it in time.
Absolutely, there's a time limit, of course, I accept that.
But section 73(1) doesn't require you to ask the tribunal to rule on it. It just requires you to raise the objection.
Quite, but in order to avoid losing it. That's what we're talking about.
Is that, so you could have said, we object that you don't have substantive jurisdiction, but we're not inviting you to rule on it, and we're not going to argue it?
Well, that's not necessarily for me to say. All I have to do is raise it. Then, of course, the tribunal has procedural powers under section 3 and how to manage it and determine it. And that's part of, that'll vary in every case. But we're talking here about what's necessary to avoid losing a fundamental right. Reading paragraph 26, putting it against paragraph 70, section 73, what it would suggest is that you're entitled to argue, or rather you'll make your challenge to jurisdiction even if it's not been raised, as long as you've objected to the jurisdiction. But there it is. If you're going to look at this, then that's definitely on the list. But in my respectful submission, we don't get here. There's no jurisdiction, and I emphasise that my primary argument in this case is that this permission to appeal application is fundamentally misconceived. There is no jurisdiction in this court, much as, however interesting, which it undoubtedly is, to entertain this cross appeal, in my respectful submission. I have one further topic, which I don't want to labour because I've dealt with this, and I'm sure this is all going to be in your lordship's mind anyway. But what we do submit on the third topic is that we did do enough. I've shown paragraph 23, which is the point we say is actually enough, but the learned judge gave his reasons at paragraph 38 as to why we had done enough and raised the substance of our objection in a sufficient way to avoid having lost it under section 73, and we say the judge correctly stated paragraph 38.5 that we'd raised the substance of the point which forms the basis of our section 67 arbitration claim. Clearly, paragraph 117 is very significant, but there is more to that, and perhaps the easiest way to do this is just to show you one paragraph in our supplemental skeleton which brings together all the relevant paragraphs on which we rely. I think it's in core bundle 1. But, tab 6, page. Sorry, big one. It's tab 6A. Apologise. At I think it's page 96.20. So obviously, the learned judge talked about paragraph 117, and that's set out at the top of the page. There are other paragraphs as well, which are equally important, which we've set out there. Paragraph 120, Crescent was asking the tribunal to go beyond the limits of its own jurisdiction. Paragraph 195, because it would require the tribunal to make legal and factual determinations under a different contract, which is not a contract within the jurisdiction of this tribunal. Paragraph 202, the parties have in no way mandated the tribunal to decide issues arising under the contract between CGC and CNGC. Such issues are outside the scope of the tribunal's jurisdiction. And then particularly paragraph 210. In sum, this tribunal, whose jurisdiction is derived from the arbitration clause in the GSPC between NIOC and Crescent, has no authority to determine the liability of CGC to CNGC under the contract. And the claimants are aware of that. Now, my lords, the learned judge said that it was implicit, but in our respectful submission, reading our submissions as a whole, it is axiomatic that the point we were taking is that on the true construction of the arbitration clause, the relevant matter does not fall within its scope. And looking at the submissions as a whole, objectively obsessed in our respectful submission, my clients raised the ground of objection that is relied upon in the Section 67 claim in sufficient specificity to avoid having lost their statutory right, their fundamental right, to ask this court to determine, as the supervisory court, the true jurisdiction of the tribunal.
So you would say that the objection and the ground of objection were taken. The only difference was that before you referred to Iranian law, it was a point you were bound to lose, whereas now you've at least got a fighting chance of winning it.
I think that's fair, if I may say so. Yes.
Well, at one point, you said that Muster and Boyd, you didn't accept that was right, and that even as a matter of English law.
Well, I think I am. What I think I said, in fairness, I think I said it's arguable. I think there is an authority dead against me on the point, and that is actually Mr. Justice Andrew Smith in Arsenovia. Perhaps I should show you this, since you mention it. It's Habas, which is in Arsenovia. It's in Bundle 1 that's being paid. So it's this is actually quite interesting because what Mr. Justice Andrew Smith was dealing with, there was essentially the same argument that we have in our case. There were two objections, in fact, but Mr. Hurst's argument was about two separate criticisms, but in both cases he was changing the system of law on which he relied upon. So before the arbitral tribunal, English law being relied upon, and then on the challenge to jurisdiction in the court, there was an attempt to rely upon Indian law, both in relation to both of the two objections. And although the first challenge succeeded, the relevant passages to consider in this context are paragraphs 58 through to 62, page 62 to 63 of the judgment, which was the question whether money was due under the SHA within the scope of the arbitration agreement in the Keepwell agreement. So obviously the facts are quite detailed. I think, although my Lord Justice Mills may know this case, but anyway, what we're talking about is...
I saw it at a later stage,
yes,
I think.
that's right. But the point we're dealing with here is whether or not a question about money due under a third-party contract is in the scope of an arbitration agreement in a different contract. So, not too far away from where we are in our case. And you'll see the argument. I don't read it all out in paragraph 58.
It does seem to be exactly the same argument.
Well, yeah, very similar. And then at paragraph 61, the authorities are, in my respectful submission, judgment of limited value is what I have to decide. The question for me is one of construction of the arbitration agreement in the Keepwell agreement. That question, as I have concluded, one of Indian law, but I can deal with it as if I'm construing an English law contract because no relevant Indian law principle of construction has been established. So it is a first instance decision. It's actually applying Indian law through the Brownlee presumption, but be that as it may, it's still an English law, it could be said to be an English law authority. And what he says, I'm unable to accept the claimant's argument. As the tribunal observed, there is nothing conceptually difficult about a court or tribunal making a determination that a debt is due under another contract in order to determine whether relief should be granted under the contract before it. This is frequently the case, for example, under contracts of guarantee. Quote, the tribunal needed to determine whether Burley was liable under the SHA in order to determine whether Unitech was liable under the Keepwell agreement. And so they had both the jurisdiction and the duty to do so. It was a question that needed to be determined in order to resolve a dispute arising out of or in connection with the provisions of the Keepwell agreement. That dispute was referred to it, and the question was within the jurisdiction, tribunal's supervisory jurisdiction, substantive jurisdiction. So I agree, as a matter of English law, the Muskell-Boyd point has that to support it, that is in a sense.
There's also something Mr. Justice Popwell said in the
Yes, you
Ruhan
mentioned
case.
that, the Ruhan case. Sorry, I didn't have a chance. I'm sure that's right, but I didn't have that
It
point
was
to
just
hand.
after the passage you showed us, and he said that frequently a court has to decide an issue between A and B, which involves deciding whether B is liable to C, even though B and C has the BC contract has an arbitration clause. That doesn't, under Section 9, prevent a court deciding the issue in litigation between A and B.
I hadn't understood. If it actually says that, I should have shown it to you, and I apologise. I thought he said nothing of what I've said before is concerned with this, but perhaps I'm wrong.
Well, maybe it is it's wrong.
No. I'm not suggesting that at all, my lord. I remember exactly how every point is formulated in every judgment. 43?
It's tab 48 in volume 4.
48. Yes.
And it's paragraph 45. Courts sometimes have to determine in a dispute between A and B what rights and obligations exist under a contract between C and D or between C and A or B, and will do so irrespective of any arbitration agreement in that contract.
Ah, well, my lord, yes. Well, that again is, I'm sorry if I didn't show you, lordship, that is quite right. Different consideration applied in such cases because of the lack of identity of parties. Not sure what the last sentence means. But yes, my lord, I accept both that passage and what Mr. Justice Andrews said. As a matter of English law, at least, the Muskell-Boyd analysis has judicial support. I accept that. But unlike the position in the Cruise City case, where Mr. Justice Andrew Smith said that no relevant distinct principle of Indian law has been established, whatever the deficiencies there may be in Dr. Makrami's report, which my learned friend will expose at trial in cross-examining him, what can be said with certainty, in my respectful submission, is that the principles of Iranian law that are relevant in this area are completely different. Try and put it not putting it too high, completely different to those that we would be familiar with as lawyers who have been brought up in the common law tradition. And that's obviously a very important point. Well, can I finally, I promise to try. My lord, I should mention, my Lord Justice Males maybe much better than I, but the problem, there is nonetheless a problem. It's not an easy solution here, and the problem of chain contracts has been around for many years, and the idea that you can have a chain of charter parties or commodity sale contracts and simply go into an arbitration between the head seller and the head buyer and say, well, I'm liable. Nobody's claimed against me down the line. but 5 contracts down the line, somebody's going to sue somebody, and that's going to be passed all up the line. I want you to look at the contract 5 contracts down and determine what the liability is under that contract, and then pass it on all the way up. And you can do that all within the confines of this arbitration. That's would be remarkable. And all I would say, this problem has been identified in GAFTA, for example, and other bodies. I think we put the rules in, which is in Authorities Bundle 5 at tab.
I wondered what on earth the GAFTA rules were doing in this case.
Yeah, well, GAFTA, yes. I think it's in tab 62, and it's really so it's 7.1 and 7.2. It's just showing how there is a problem, and what the commodities bodies and various other bodies have done is basically provide some rules to provide solutions to what would otherwise be jurisdictional problems by providing for consolidation, concurrency, and so on. But anyway. Nonetheless, I accept, going back to my Lord Nugee's point, that the Muster Voider has got some support from both Mr Justice Popwell and Mr Justice Andrew Smith. Now, the final point I wanted to mention very briefly, although I don't want to dwell on it, is this Geneva point that my learned friend has mentioned. Now, this was debated at great length before the judge, and we would respectfully submit it's a point devoid of... It's a forensic point, no doubt, but it's a point devoid of substance, and the reason for that is explained, and I'm going to give you the references, in Mr Howarth's second witness statement of paragraph 33, which is in Supplemental Bundle 3, tab 12 at 1236, and in his third witness statement of paragraphs 18 to 19, Supplemental Bundle 3, tab 14 at 1272. And the key point here is what those submissions were directed at was not Article 22 of the GSPC, but an alleged agreement reached after the arbitration, which curtailed the jurisdiction of the London Tribunal. That's what those submissions are directed at, and they're also directed to the Geneva Tribunal, not the English one. So, prejudice, of course, inconsistency in that sense, but not of a legally material or significant nature, and hence the learning judge below ignored them, and my submission, he was entirely correct to do so. My lords, unless there's any questions, I can assist you with. Those are the submissions on behalf of me.
Yeah. You have mentioned once or twice being a bit concerned about time constraints, but I take it that you've made the points that you feel you need to make in order to present your client's case fairly.
My lord, that's right. I've tried to finish within the original estimate 2.5 days, but I did ask yesterday, and you did give me an answer that I could go into the afternoon, and I appreciate that. But I've tried to use the time effectively to deal with points at the heart of the matter.
Yes,
I haven't repeated my skeleton, but all those points I've
you've done
as
that.
well.
Anything you want to ask us? No? Well, thank you very much, Mr. Mayor.
Right.
Right, Mr. Dewan, you've got a reply on this. The ground's been pretty fully covered, but I'll make the point you want to make.
I'll try and be very brief, but and thank you for the indication. Can I, since we were debating Section 73, may I start with that, if you don't mind? First of all, a few brief points. On statutory language, on the use of the word that, in my submission it's rather important because, and it was picked up in one of the cases, in the AEK Basketball Association, the court there thought it was rather important. That's volume 1, tab 2, page 26, Athletic Union, at paragraph 21. The reason why I say it's important is this. That objection indicates there can be more than one objection. Because otherwise, why do you say that? And what does that mean then? Because if all you have to say is I object, for example, to the claim for damages because you've got no jurisdiction, that can be on different bases. So is that the same objection? If you're doing it on the basis of scope, arbitrability, they are not the same objection. Even if, leaving aside the judicial gloss really is reflecting the fact that it's that objection in my submission. Also, again, one shouldn't forget the defence in the statutory language, which refers to grounds. Could with reasonable diligence have discovered the grounds for the objection, which in my submission meshes with that. So that's the first point on section 73. My second point is with respect to the sort of radical, what I would describe as a radical case as to the nature of a section 67 rehearing. And can I just remind the court, in terms of this notion that it's a free-for-all, no control of evidence, nothing, what Mr. Justice Akins, as he then was, said in the prime trade case, which is Legal 3, tab 40, at page 888. Paragraph 62. Because he's dealing with the issue of new evidence. And in fact, if I remember correctly, Lord Justice Mayles actually dealt with an issue of controlling evidence on a section 67 rehearing at first instance. There is a case. Yes, I can't remember the name, but I recall, because in the new Muslim Boy that I'm drafting, I've been referring to it.
I think it might be called The Quest.
I think it wasn't request. It was Robert Bright was the counsel.
Yes.
I can't remember.
Anyway.
Anyway, there is
So
such
the
a
point-
case out there somewhere.
The point here is that Mr. Justice Akins is talking about controlling evidence, and he refers at the fifth line, but that cannot stop the court exercising control over what evidence to admit on appeal. Appeals under that section, after all, are rehearing, not a complete fresh start. And that's where my learned friend and I differ fundamentally. If it's a rehearing, it by definition means of something that's been addressed by the tribunal. Now, the fact that there's no evidential weight given to the tribunal's determination, in my submission, is beside the point. The point is that it has been determined by the tribunal. It's not about just a complete fresh start, and that's how the whole system works. And if one, in that context, just recalls, if we go to volume 5, tab 60, page 1478, the DAC report on competence. I'm just somewhat confused as to how my learned friend's case works in practice. If we go to page 1478 and clause 30, the DAC commentary, so volume 5, tab 60, page 1478, what is said here is the great advantage, at paragraph 138, the great advantage of this doctrine is that it avoids delays and difficulties when a question is raised as the jurisdiction of the tribunal. Clearly, the tribunal cannot be the final arbiter of the question of jurisdiction, for this would provide a classic case of pulling oneself up by one's bootstraps. But to deprive a tribunal of a power to rule on jurisdiction would mean that a recalcitrant party could delay valid arbitration proceedings indefinitely by making spurious challenges to the jurisdiction. Because that's the very purpose of competence, that you can't stop the arbitration from proceeding, because if you can simply make an objection and the tribunal can't rule on it, then by definition you have to stop the proceedings and have it go to court. But that's not how we're set up. The only situation where that's set up is either through a preliminary point. Sorry, that's not how it's set up under the 96 Act. Either it's a preliminary point of jurisdiction by agreement, or you choose not to participate, and then there's an issue as to whether you can take the jurisdiction point straight away or at the end. But that's an issue of argument. But so once you choose to participate, in my submission, you have agreed to the exercise of competence by the tribunal. Now, and I do, so there's only two other points I want to make on section 73, and then I do need to get to the jurisdictional threshold point. So the point of this, reliance was placed on the Poland case, a case I argued, for the proposition that if you are arguing that the tribunal has jurisdiction, when the point is made when the tribunal concludes it doesn't have jurisdiction, then there's no waiver in place. Now, I don't accept that as a proposition. It may not be waiver under Section 73, but you still have the right to invoke waiver. And I'll just give you the reference, which is Volume 2, Tab 19. That's the Poland case. But just to be very clear, the tribunal ruled it had no... well, we can, since you're taking that, Volume 2, Tab 19. If we go to... paragraph 101. What's interesting about that case is the tribunal concluded it had no jurisdiction over a fair and equitable treatment claim under an arbitration clause in a treaty. And I argued that it had, on a Section 67 rehearing, that it was wrong to conclude that. So there was actual decision on the question of construction. And what the other side, and that's at 101, you can see that. Because the court is explaining where the tribunal went wrong. So you've got a decision of the tribunal, as you would expect, on the issue of construction, and the court's pointing out where it went wrong. Now, on this issue of rehearing, one of the points made, and you'll see this at paragraph 72, which was made against me, is, oh, well, you've improved the arguments which were made before the tribunal, and you shouldn't be allowed to do that. And so the court simply said, well, fresh arguments, new arguments, that's fine. It didn't address the question if a completely new point had been put, whether there would be waiver or not. So I'm not sure about this asymmetry. I don't accept this case stands for a proposition of asymmetry.
But the fact is that Section 73 is not in point in that scenario.
It's not. It's not in that scenario.
I think the point is
you might
that supports a narrow interpretation of Section 73.
I have difficulty with that proposition because obviously waiver of a jurisdictional objection is a fundamental principle. There's no reason. Normally, once waiver is such a fundamental principle that the fact that a party is saying you've got jurisdiction when you haven't, which is an unusual situation, is not something catered for, doesn't necessarily call for a narrow interpretation of such a fundamental principle. I'm not sure why there should be symmetry of the points, in other words. Now,
Mr. Justice Bryan at 72 seems
Yeah.
to say it's difficult to see how a waiver could arise.
of an argument.
He says the requirements for a waiver have not been met. That's your right to advance arguments.
Yeah.
And then he says, and it is difficult to see how a waiver could arise in circumstances where it is well established that there can be a rehearing under Section 67 if fact parties are taken to know.
Yes, but a waiver...
That's rather against your submission that you can, in the position you found yourself in, waive your right to take points.
Well, in my submission, he's not addressing the distinction between grounds and arguments.
I see.
Because that wasn't an issue. Because it was obvious that the point had been taken before the tribunal.
I
The
see.
point of construction. That's my point, and that's 101. You don't waive arguments even under Section 73.
Yes. Okay. Thank you.
Now, a point. I do need to. I don't want the court to think that somehow I misled Mr. Justice Butcher in the way that I put the case to Mr. Justice Butcher. There were some submissions which suggested that he adopted the substance point from me. Can I just take you to Supplementary Bundle Volume 4, Tab 23, at page 1398. And if you go to page 23 on the left-hand side, lines 18 to 21, as I indicated to the court, I had actually put the Lord Goldsmith point to Mr. Justice Butcher, And then I say at lines 18 to 20, that is why I have said properly and fairly put for determination. I was putting exactly the same point as I'm putting before the court, just to be clear. And so far as Concola is concerned, yes, I haven't specifically mentioned it, but my argument, ground 2, clearly and squarely puts the question of fairly and put for determination by the tribunal. Concola is my speculative explanation as to why the court seems to have not asked that question by the narrowing of Proposition 7. But I'm not dependent on Proposition 7 and his narrowing for my point, which is fundamental principle 1 of the ones that he set out is the principle of fair, openness and fair dealing. And so I only need to rely upon that for the proposition that I'm putting forward in my ground 2. Now, that's all I wanted to say on Section 73. Would the court give me the indulgence of 5 minutes now or not?
Can you complete what you need to say in 5 minutes?
Yes.
Oh, well, let's do that, rather than send everybody away and come back at 2 o'clock for 5 minutes.
I thought it might be more helpful for everyone.
No, if you can do it, that would be splendid.
Okay. So the first point is, the point is put to me that on jurisdiction is that the costs order, we were challenging the costs order and that we needed therefore permission because that went to Section 60, a decision under Section 67. Now, just to be clear, my learned friend had already put the costs order in issue under his notice, so I'm not clear why I would need permission. Core bundle 1, tab 1, page 5. It's already an issue under NEOC's notice. So, in a sense, it's a little bit of tail wagging the dog to focus on costs, because if the position is as I say it is, then if it is necessary to separate out costs for that purpose, then so be it. But that shouldn't be the basis on which the issue of principle is decided. Now, sorry, my next point. Reference is made to the fact, reliance was placed on the fact that Section 73 is referenced in Section 67. I would remind the court again that it refers to may lose the right to object, which is why I say it's simply descriptive of a scenario that may happen, and it's the may that's important. It's not just about the linking, so the question is whether it happens. Now, a point was made by Lord Justice Nugee about whether reliance could be placed on Section 1A and the final resolution of disputes, and whether that could be seen to be added to thereafter. Now, that does run into the various points of policy that I raised yesterday, including under Section 66 and 103, because if you're drawing a point after the award, why are there no restrictions on appeal under Section 66 and 103? Just to, and you'll forgive me if this is too forensic, I can't help but note that my learned friend didn't engage with the points I made on Section 69.8 and my lady made on Section 69.4 or 5 on why is it limited to the ultimate decision, or a decision along the way is specifically provided for. How does that tally with Section 67 and 68? And I've already made my points on the policy of Section 73. Now, the final point I want to address is this notion that the court has a discretion to refuse permission on the basis that I did not seek permission before the first instance court. Now, can I just take you to what the White Book says on this, which is volume 5, tab 69. At page 1561. And reading from halfway down. Commentary in successive editions have suggested that although the rule in general terms gives parties a choice, they may be well advised to apply for permission. The reasons are, and then it gives various reasons as to why it's beneficial, but it doesn't suggest in any way that that's a reason that there's a general discretion to refuse, or that that should be an issue in play for having, in not having sought permission. And of course, the reason why I referred to the Kabaji decision was that's an example, because I was in that case, where Lord Justice Mayles granted permission and it wasn't even sought at first instance before Mr. Justice Burton. And there's one other point here, which is it's worth looking at Mr. Justice Butcher's reasons for giving permission, Call 1, tab 15. And at paragraph 7 on page 157, we submitted that permission to appeal would be undesirable because it would cause further delay in an arbitration process which has been excessively drawn out. And what Mr. Justice Butcher said, I do not consider that this can affect my decision on permission to appeal, which must depend on the application of the agreed test and the circumstances of a summary dismissal. So Mr. Justice Butcher put me in my place for suggesting that there's some other factors that are to be taken into account. It would be rather surprising if there were other factors, because the test under CPR 52.6 doesn't make reference to that. I can well understand that this. There are sometimes appeals against after a lengthy trial where there's been a lot of evidence and so on, where the court may not be in a position. I've seen some comments where the first instance judge's observations on the evidence and so on may be something which is material for the purpose of the permission. And that may be a different situation, but where we're dealing with pure points of law, it cannot be right that it's relevant to the question of permission if I overcome the jurisdictional threshold. Those were my submissions.
Well, thank you very much. We will obviously reserve our judgments. They will be sent to you, those whose names have been submitted, in the usual way for correction of any typographical or minor factual errors. You will, I'm sure, appreciate that the embargo applies and the court takes that very seriously. I'm sure everybody here knows that, but I'll say it anyway for the avoidance of any doubt. We will hope that in the light of whatever we decide, you are able to agree an order and submit it to us for our approval. If you're not, we will have short submissions dealing with any points in issue, and we will resolve those without further hearing. Apart from expressing our gratitude to all concerned for the interesting arguments we've had over the last couple of days, that concludes the appeal. Thank you very much.
Thank you.
Court rest if able.